All right, so the motion regarding the testimony of Dr. Laposata. So the Commonwealth is moving specifically to exclude, there's a motion to exclude irrelevant photographs. We'll deal with that after the main motion to exclude certain testimony. So if we start on page 7 of the report, that's where you want me to start, Mr. Brennan?
Your Honor.
Okay, page 7 of your report. I have some questions. So, Mr. Jackson, Dr. Laposata cannot opine about the investigation of the case, the law enforcement investigation. She does that throughout her report. So she can't opine to that. But when we get to page 7, what do you say is out, Mr. Brennan? I mean, I've gone through it. I know what I think, but it's the Commonwealth's motion.
I think that her opinion about no object being present to cause a pattern injury is appropriate.
And where are you, on page 7, the first paragraph?
Yes, photographs and descriptions of the site. It is the...
All right, I might have a different page 7. So my page 7, okay. Okay, yep.
Dr. Laposata's proposed opinion that photographs and description of the site where Mr. O'Keefe's body was found show no object capable of producing a pattern injury, I think is appropriate. His body was found on flat, grassy ground, probably frozen and covered with a minimal amount of snow. I agree is appropriate. It is the next paragraph where it begins in the middle of the sentence. It is logical to conclude that Mr. O'Keefe was injured elsewhere and his body was moved to the front line. There is no basis in fact for that. It's an improper opinion.
Yeah.
We left the argument.
So I told you that on Friday, Mr. Jackson. Great. Okay, so that's out. And Mr. Jackson, again, the medical examiner erred in her diagnosis of hypothermia. Again, that's the improper critiquing of the expert. She can say that it wasn't hypothermia, obviously. Okay, so same with the first sentence of the next paragraph, the Wisniewski spots were misidentified. Great. All right, so we can probably do this much quicker then. All right. All right, so page 8 is fine. So now we go to page 10. So this is the dog bites. So if you want to pick it up at... What does the Commonwealth say about this?
At this point, there's no basis provided that she has the training, expertise, methodology to provide an opinion regarding a dog bite.
What's the offer of proof on this, Mr. Jackson?
It will be more extensive when I establish the foundation testimony. Basically, she's not only done autopsies involving dog bites, the wound pattern recognition related to the source of those dog bites. She's also taught classes on wound pattern recognition, source of coming up with diagnoses concerning the source of specific pattern of wounds. She has a methodology that she uses. Medical school classes, I didn't mention the courses.
What does she teach? Is this in her CV? Because I didn't see it.
It will be in her foundation that I will lay in front of the jury.
All right.
I don't see any opinion unless and until the foundation is properly laid, but she has extensive experience, not only with specifically with autopsies that she's conducted herself, but supervising autopsies of others that deal with pattern recognition, the methodology involved with pattern recognition.
How about dog bites?
Dog bites, specifically 5 autopsies. I believe she will indicate that she's done 5 autopsies as they relate to dog bites.
Okay.
A medical school class specifically on the issue of wound pattern recognition, which that class includes dog bite recognition.
All right, so we'll need a short voir dire of her on this before she testifies.
Because the court doesn't believe that I can lay the foundation in front of the jury and just forego a voir dire. I won't ask any ultimate question until we go to sidebar, but I think we can short circuit that.
Well, she's very specific about the dog bites here. So if she's seen 5 autopsies with dog bites, I'm not inclined to give it to you. Okay? Seen only 5 in her 40 years or whatever.
It's not that she's only seen 5. She's performed 5 autopsies.
Okay, so that's why we need a voir dire. So we need a very short voir dire.
She's also been qualified on the issue of dog bite wound pattern recognition in federal court as well.
Okay.
So she has a plethora of foundations.
Has that been provided to the Commonwealth in advance of today?
I don't know.
None of it has. So here's the difficulty, whether it's a voir dire or it's in front of the jury. I have absolutely no ability to research and cross-examine her on dog bites. She can say she had 1 case or 50 cases, that she testified in state or federal court, or she took a class. I can't verify it. I can't contradict it. I have no ability to prepare for this witness about her basis, methodology, and experience in dog bites. What I have is her showing a couple pictures that she pulled from a book, and then she has some Google or Shutterstock research in her report. And so the idea that she has a history or basis is going to be uncontested, because there's nothing I can do to contest it, and that's not appropriate. I should be able to research, get transcripts, vet, and be able to approach the witness on whether or not she actually has the reliability and education and experience. I can't do that if we call her and ask her for the jury or a voir dire.
No, that's where, if we want to compare apples to apples, Dr. Wolf, Azek Wolf, was allowed to testify, to specifically testify to the wound pattern, or his interpretation of wound pattern recognitions back then. That was nowhere in his report. That was objected to by the defense. Mr. Alessi went to sidebar, strenuously objected, said this is nowhere in the report. We didn't have any notice of this. And the court said, overruled, he's allowed to testify to the pattern of recognition. At least in his mind, you can cross-examine that line. There is no requirement that the Commonwealth have every single case that Dr. Laposata has ever dealt with, dealing with.
No, we had an expert on dog bites who I allowed to testify as to dog bites based on, we had a whole, as you know, it was Mr. Leslie, I think 3 days with Dr. Russell on the voir dire. This is new to me. I'm going to have a short voir dire on to what she can testify to.
I have no problem with voir dire. I just wanted to short circuit it. But
So, all right, so let's go on to page 17.
Commonwealth has an objection to the third line. Mr. O'Keefe's pattern injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm. She is not qualified as a reconstructionist or biomechanical engineer. She has tried in other courts and been rejected. She does not have the experience, the background, or the ability to do that any problem.
What do you say, Mr. Jackson?
No, I believe she does, as a medical examiner, have the experience, and it's the qualification, it's the specific job of, and the qualification of a medical examiner to opine on pattern injuries. If the foundation is laid, especially as it relates to motor vehicle accidents, and now we're not talking about dog bites, which are a more defined subset of her overall experience. Now we're talking about motor vehicle incidents and accidents that she has specifically seen thousands of.
Okay.
Multiple thousands.
So
If she does have the qualification to say, if the proper foundation is laid, that the wound pattern that I see on Mr. O'Keefe's arm is inconsistent with anything that I've seen in terms of a motor vehicle accident.
So let's just find out how many motor vehicle accident autopsies she's done during that voir dire. What I have a question about is tail lights are typically made of durable polycarbonate or acrylic plastic. I would keep that out. I'd be inclined to allow in the injuries on his right arm do not correspond to injuries that could have been produced by plastic pieces impacting his arm. But let's hear about that.
I wouldn't ask about polycarbonate. I have no intention of asking about that.
And also the last sentence, I think it's okay, and we'll see with voir dire. Neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes, assuming she has experience with autopsies of motor vehicle accidents. But I would keep out the the part as would be expected from pieces of shattered tail light. Was there more on that?
I object to that because this is now yet another witness that is coming in under the guise of some type of specialty, but really for accident reconstruction.
All right, so let's see what she says on voir dire regarding her experience with accident victims. I think she gets more into the accident reconstruction on the next page that I don't think is proper.
Which I am not seeking to choose.
All right, so that whole first paragraph on the next page, you're not seeking to introduce? Yeah.
At least the first, we're starting with the first sentence. Yes, we would be seeking to introduce that. Pedestrian injuries produced by contact with motor vehicle include a component of tissue crushing force as the car profile protrusions connect. That's basic. I believe that she does have the qualifications to opine about that. That's pretty standard, and that should be admitted.
She has absolutely no experience in accident reconstruction or the injuries. She is not a biomedical engineer. They have one, and he's going to testify to it.
Yeah, I have that as out, Mr. Jackson.
The reason that I believe that it's appropriate is because you don't have to be a biomechanical engineer to understand when you see, for instance, a known pedestrian accident, what are the results, especially if you see hundreds or maybe even thousands, what are the results that you typically see in the movement patterns, for instance, crushing forces, broken bones, fractured bones, crushed soft tissue, things of that nature, internal bleeding. That's the province of medical exam.
Okay.
That's exactly what they are trained to identify and to opine on.
Okay.
I wouldn't get into things like, for instance, what she doesn't have the experience to do is say, when a car is involved in a rollover collision, these are the mechanical forces that are exerted on the body during a rollover, and the G-forces that the body is subject to in a rollover, things of that nature. When a car is impacted head-on by another car, there are a number of G-forces that are put upon the body, etc. Those are biomechanical issues, have nothing to do with her expertise, and I wouldn't be seeking anything like that. But once the body is removed from the car, and then it's on the autopsy table, that's where her expertise begins to fly.
Okay.
She can talk about, and I believe she has the experience and the qualifications to talk about, what the body suffers at the hands of a vehicle, pedestrian incident, or accident.
Okay. So the first two sentences are out. The third sentence, she can testify that Mr. O'Keefe had no bruising on his arms or torso. And she can testify, and she cannot say that would have resulted from the impact with the SUV rear profile. She can say Mr. O'Keefe did not have bruises on his legs. She cannot say from bumper contact, but she can say as shown by dissection of leg tissue and muscle at autopsy. And she can't testify to anything else in that paragraph.
Okay. Your Honor, is the court ruling that she cannot say anything about the human body contacting a motor vehicle? That sounds like what the court's saying.
No.
I think that's too narrow a ruling.
It is. You can put this in. What I said you could put in can come in, and the rest cannot.
For instance, and this for point of clarification, if I ask her, would you expect, I'm just going to make it a hypothetical, would you expect if his legs were contacted by a moving vehicle, would you expect to see a bruise or contusion?
What do you say about that?
I object. One, it's leading. Secondly,
Well, I'm not asking the question.
Secondly, this is asking to have Dr. Laposata do accident reconstruction. She's not assessing a wound. I'd ask you to consider the case of Cromwell versus Tompkins, appeals court. I think we provided at 105 Mass Ave 1124, 2025 case. And a similar attempt was made to try to use Dr. Laposata as a biomechanical accident reconstructionist. The trial judge did not credit her proffer and found that she failed to meet the requisite criteria pursuant to Daubert Flanagan. And so recently it's been found by at least another court that she is not competent to do this. Because she's a medical examiner, does not allow her to come in and start endorsing or vouching for the article witnesses. They already have witnesses to do that. And so not only on page 18, going back to page 17 of about the pattern injuries or corresponding injuries to a light, she would only know that if she had the training
Where?
and experience.
I'm sorry. Where?
You said on page 17 you would allow Mr. O'Keefe's pattern injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm. That's not her role as a medical examiner. That is the role of a reconstruction or a biomechanical engineer. And she clearly is not competent, at least as cited by the appeals court, to have that type of opinion. And so there's one thing to assess wounds, there's another to try to correlate or draw a distinction between the wounds in a car collision. It is essentially giving an opinion to the jury, he didn't get hit by a car. That is the core fundamental theory of the defense. This is simply trying to bootstrap another witness to give that opinion. That's improper.
All right. Sure.
Mr. Brennan's going to cite the Tompkins case. He needs to cite the Tompkins case. That dealt with a situation in which the witness was called, and she was asked by the lawyers, specifically in that case, the people that called her, the lawyers that called her, to opine about blood-stain pattern recognition, blood spatter evidence on the driver's seat versus the passenger seat, and what her opinion was about who actually was driving the vehicle. It was a rollover collision in which people were ejected from the car. She was then asked to opine about bloodstain patterns in the driver's seat and whether that was more or less consistent with the blood, the originator of the blood, one particular individual, was he more likely in the driver's seat or the passenger seat at the time of the bleeding, and was it before or after the rollover? Very, very different set of facts. And of course, that is a biomechanical engineer's province. And the court was correct in saying, I'm not going to credit her testimony on that issue, but that's what she was asked. She opined on it. The court said, I'm not going to credit her testimony.
All right, so
this type of analysis and wound pattern recognition, which is what she's being asked.
So let's see with her voir dire this morning.
Okay.
She actually was allowed to testify about blood spatter. It is the reconstruction testimony that she was not allowed to testify.
I read the Superior Court judge's decision. I have not read the appeals court rescript, so I need to do that. I'd like to get going, but there are photographs of inside the garage. You intend to put this in through Dr. Laposata?
No, not through.
Through whom?
Can I do this? With regard to these photos, well, ultimately, the Laposata will be shown them, correct? That they'll be introduced through our investigator who took the photos. We intend to call that investigator after Dr. Wolf testifies.
And what will that investigator say? These are photographs.
So he will testify to two subject areas. One would be he took measurements from the street to the various entrances to 34 Fairview. I would just have to testify about what those measurements were. And then where he took several photographs, we have pared them down to, I think, 3 or 4, just of one establishing shot showing the garage from the street, and then a couple of photos showing the side entrance to the garage, the pedestrian entrance to the garage, which also shows...
How are they relevant?
I'm sorry?
How are they relevant?
So the defense is presenting a loading defense in this case. We are alleging anyone other than Karen Reed from Fairview Road to the house, taking approximately 36 steps over a distance of 25.4 meters, which is approximately 84 feet. That is consistent with him entering the house. It's consistent with him entering the garage. The police did not take photos of the garage. They didn't investigate, is there a hard surface in the garage? Is there a ridge-like surface in the garage? And these are photos are introduced on that road mission to say that there was evidence in the house. If the police only went in there, they would have seen that. And that may have sent them in a different direction. So it's relevant for that purpose.
Do you want to weigh in on this?
These are not only relevant and not material, it's misleading. They are not seeking to have measurements from the flagpole to the door. They're trying to seek measurements from the driveway to the door. There is no evidence whatsoever John O'Keefe was ever on, near, or anywhere by the driveway. The evidence is that he was at the flagpole. While the data showed there was a turn westward, it didn't show movement westward. It did not. If there was a measurement from the flagpole to the garage door, that is something that I think would be appropriate. From the driveway, totally irrelevant. There's no evidence, no witness, no substantive evidence in this case that John O'Keefe went in the house, went near the house, was dropped off. They're relying simply on the fact that there were 37 steps. They have no idea what direction or where. What they want to do to argue this is to show inside the garage and then posit a theory that somehow John O'Keefe was killed in the garage, it was colder than it was in the regular house, that would account for the temperature on the battery. They have no evidence to support that. You can't use Bowden as a panacea. You can't just say Bowden, they should have done what we want them to do. It is what is reasonable. The police went into the house. They spoke to the occupants of the house. There was no evidence that Mr. O'Keefe went into the garage. You might as well take a photograph of anybody else's garage in America and put it up in front of the jury. So this is going to create a mistaken, baseless argument that this evidence somehow shows that Mr. O'Keefe was A, in the garage, and B, he was injured in the garage. That's why they want to show Dr. Laposata. Couldn't some of these angles have caused the injury? Total speculation, no relevance at all, and it is just prone for an opportunity to mislead this jury. This should not come in.
If I may respond in 4 ways. First of all, Mr. Brennan just informed this court that there was no evidence of the movement of the phone. I'd like to quote his own witness. At 12:25:30, the device's bearing shifts to a westerly direction, as location records also show the device moving west from the roadside toward the house. So that was false. Secondly, with regard to, we should be measuring from the flagpole, our theory is not that he entered the house from the area of the flagpole. Our theory is that he was placed at that flagpole, and as Mr. Brennan correctly points out, there's no evidence that they introduced as to where he was on the road prior to walking into the house in that westerly direction. Our theory is as good as his. He cannot prove anything to contradict our theory. The third thing is that Ryan Nagel and Heather Maxson saw Karen Reed in her vehicle alone. The passenger seat was illuminated and empty. John O'Keefe was nowhere in the area of that vehicle. He was not in that vehicle. There's only one other place that he could be, and that is in the house. So finally, the fourth point, Your Honor, this court has continually always done, as the court should, a 403 analysis. The probative value we have established through their own witnesses. They called all these witnesses, and they established the foundation for the admission of these photos. There is no unfair prejudice. I argue that any time there's exculpatory evidence or a case that advances the defense theory, that's by definition going to prejudice the Commonwealth's case. This is not unfair prejudice. Mr. Brennan is allowed to cross-examine this witness and to make whatever arguments he wants to make about the likelihood of the garage being involved or not. But he does not and should not get the benefit of the fact that his investigation, the police investigation, didn't do what we just did. And this evidence should be admitted.
The argument is purely rhetorical. There's not one fact he offers. The witnesses that saw the car saw it in front of them. Nobody ever got out. A light on doesn't mean that he wasn't near the car because they didn't see him in the front seat. So there is no evidence that Mr. O'Keefe went anywhere near the house, on the breezeway, in the door. It is speculative. It is baseless. They want to take that baseless argument and then bootstrap it to Dr. Laposata to further speculate that something in the garage that could have caused the injury. That is not Bowden. That is not a due process right. That's not 403. It's empty. It's no factual predicate whatsoever.
Okay. So
The only other thing, just to put a cap on this, the location data circles, again, Mr. Brennan's own evidence, he introduced it, puts John O'Keefe in the house.
all right, so I'm going to allow you to do the measurements. These photos will mark for identification. The photos are not admissible.